All right, everyone. Good morning. All right. So over here, you guys are all awake, but over here, that was like a small good morning. Good morning, everyone. Awesome. I want to make sure that everyone is wide awake and focused. So you are in the 187 District Court. I'm Judge Stephanie Boyd. You are on the 4th floor. So what court are you in? All right, you all are acting like you're singing the Old Lang Syne, where you sing it, everybody knows the first words, then everybody just drowns off. So what court are you in? Which floor? And who's the judge? All right, now you're probably asking, yeah, there was a little drown off on that one too. But you're probably asking yourself and saying, excuse me, Judge, we know where we are. Why are you asking us this question? It's based upon experience. Sometimes when we take a break, a juror will wake up or look up and everybody's gone and they forget where they're supposed to be. And we actually had a juror one time who was trying to get on another jury panel, and they'll tell us, I looked up and everybody was gone. So if that ever happens to you and you get left, if you remember the 187 District Court, there's only one 187 District Court, not only in Bexar County, but in all of Texas. There's only one Judge Boyd in Bexar County. So if you mention any of those things, people will be able to direct you where you need to be. So in your possession, you have something that is very expensive. They are numbers. Could everyone please hold up your number? All right. So whenever there's somebody who asks a question of you, and if there's something that applies to you, or there's something you want to say, before you say anything, just hold up your number, and then the attorneys or myself will recognize you, and then you can speak. To my left, and you can lower your numbers, to my left is the court reporter. Can you raise your hand? All right. I believe that everybody's job, if you can make it easy for them, then make it easy for them. I always said when I would work for other people, if only they would do things this way, my job would be so much easier. So as a judge now, I try to make people's jobs as easy as possible, if I can. So in order to make her job easy, I need everyone to speak clearly. So it's okay if you feel like you're yelling, that's fine. She's going to appreciate that, because she has to take down everything that everyone is saying. And when you really think about it, not only does she have to take down what everybody's saying, she has to put in who said it. So if I'm speaking, she has to write in judge and then put down what I said. If the attorneys are speaking, she has to put their names down and say, this is what they said. And when you think about it, everybody speaks at a different pace. Some people whisper, some people are speaking very fast. So if everybody will speak one at a time, speak loudly so she can hear. And if you speak at the pace that I'm speaking at, or maybe a little slower, it will make her job so much easier. The other way we can make her job easier is this way. Can everybody in this box raise your card for me? And don't lower your card until I tell you to. Everybody on this front row here, raise your card. Nope, just the front row, number 25. No, not you. You can lower your card, 25. So everybody who has your card raised, if you're answering a question, you don't need to stand. She will be able to hear. Anybody who does not presently have their card raised, if there's something you want to say, and if you can, to make her job easier, we'll need you to stand when you're speaking. Can everybody do that? All right, you can lower your cards. Now, I will tell you, when I say that to a jury, guess what? Everybody says we're going to do that. And then guess what ends up happening? They don't do that. So I'm dependent on every juror here. If you see somebody who should be standing and they're not, just give them a little nudge and say, please stand. All right. So this case is the state of Texas versus Mr. Dixon. So I'm going to have the parties introduce themselves to you. For the state,
Daniel Escobar for the state of Texas.
Jason Garaham.
and for the defense,
My name's Adam LaHood. I'm a defense attorney.
George Schaefer. Anyone know me?
All right. And Mr. Dixon. All right. You may be seated. Now, those parties who have just introduced themselves, does anyone know any of those parties? If you do, just raise your card and let us know. You need to raise your card.
Sorry.
All right. Number 64. All right. 64. Who do you know?
One of the attorneys.
All right. And that would be Mr. LaHood. See, everyone, we're already off to a bad start with the standing. All right. We're going to pretend like that did not happen. So we're starting over. Everyone, please remember to stand. All right. So you say you know Mr. LaHood? All right. Thank you. Number 58. You may be seated.
Jason Garahan.
Okay. All right. And 64. How do you know Mr. LaHood?
I don't actually know him personally. I know him visually. He used to live in my apartment complex.
Okay.
We spoke occasionally. And I think it was before, I think he was going to law school at the time. He wasn't even an attorney yet. So we're talking probably 10 years ago.
All right. Was he a good neighbor?
Oh, yes.
Okay. That's what he wants to know. So I'm going to ask you. Thank you. All right. Number 58. Who do you said Mr. Garahan?
Yes,
All right. How do you know him?
we're members of the local San Antonio A&M club, visited several times.
All right. And you say A&M Club.
Yes.
Is that Texas A&M?
Texas A&M.
All right. As an LSU talk, I'm not going to hold that against you. Okay. All right. Thank you. All right. So the charge in this case is murder, right? And I know when people show up for jury duty, sometimes you're like, please, can I get a car accident? Can I get something else? But in order for us to have jury trials, guess the number one thing that we need? Jurors, right? So what I want to I'm going to talk about that charge in a little bit, but the attorneys are each going to have a chance to ask questions of you. Before they ask those questions, I'm going to make sure that you all have your lunch break. So we're going to come back with their questions for you after lunch break. But when they talk to you, they are not allowed to talk to you about what they think the facts are in this case. So everything that they talk to you about and every question that they ask you are going to be hypotheticals. The only way you'll know about what they think the facts are this case is if you're actually on the jury. Does everyone understand? So when they're speaking to you about something, don't go in your mind and say, so this is what this case is about. They're not allowed to go into that. Does everyone understand? Yes. Now, this case was brought to this court through what's called an indictment. Has anybody heard of the word indictment before?
Yes.
So an indictment is really just a means by where someone is brought to court. It's not evidence of anything, and it cannot be used by you as evidence of guilt or anything. Does everyone understand? Yes. So, for example, here's a chance for you to raise your cards. How many people here have ever had a traffic ticket? All right. So this is one of the worst driving jurors that we've ever had up here before. But I've had a traffic ticket before. And when I got a traffic ticket, it was back in the day where the officers had the paper tickets. So I know you're saying, but you're only 21. How could that be? So, okay, there should not have been much laughter for that. But when you get a traffic ticket, let's say they say that you ran a stop sign, right? When they give you that traffic ticket and you accept that traffic ticket, you're not saying, oh, yeah, I ran a stop sign. That ticket is just telling you what you're charged with, what they're accusing you of, where you need to be to answer for those charges if you would like a jury trial. So it's not an evidence of guilt at all. And it's not to be taken as anything other than this is a traffic ticket. This is what I'm accusing you of. And this is where you need to be. Does everyone understand? Yes. So an indictment is much the same way. This is the indictment. This is where you need to be if you want a trial. Does everyone understand?
Yes.
And it cannot be used by you as evidence of anything. Does everyone understand?
Yes.
Is there anyone here who cannot follow that instruction? All right. Now, the next thing I want to talk to you is certain rights that people who are accused of offenses have. One of them is the right to remain silent. Has everyone heard of that before?
Yes.
Oh, a lot of people have heard of that. That's great. So a right to remain silent, that means that a person really doesn't have to testify if they don't want to. I've been a defense attorney. I've been a prosecutor. Sometimes when I would have a client, I would say, hey, you don't need to testify. The state didn't prove their case. Or sometimes you will have somebody who they stutter, they're afraid of speaking in public, they're nervous because, hey, I got to get up here and speak in public. So there are many reasons why a person may decide not to testify. Does everyone understand? And you cannot hold it against them if they decide not to testify, because if you can just imagine, if a person were going to testify, they have to sit here and everybody's staring at them. So that's a pretty hard thing to do. So is there anyone here who will hold it against Mr. Dixon if he chooses not to testify?
No.
Okay. Now, the other thing I want to talk to you about is presumption of innocence. I'm sure you all have heard of that. Is that correct? So everyone who's charged with a criminal offense is presumed to be innocent. So if we were to take a poll right now, and I were to ask you if Mr. Dixon were guilty or not guilty, what should your answer be? Because you haven't heard anything, right? So a presumption of innocence means that the state has to prove their case beyond a reasonable doubt, and they have to prove every element of the case. So they have to prove, for example, the day that something happened, that it happened in Bexar County. And if it were a robbery or if it were a burglary, they would have to prove every single element beyond a reasonable doubt. Does everyone understand?
Yes.
So what that means, since they have the burden, that means that the defense does not have to prove anything. When we're in law school, we were always taught, if you're a defense attorney, you could sit over there, you could play Scrabble, you can do crossword puzzles, you can play video games. Of course, again, when I was growing up, we didn't have video games by cell phones. We didn't even have cell phones, but they could do that. And the reason why our professors would tell us that is because they wanted us to 100% understand that as a defendant and as somebody accused of a criminal offense, you don't have to prove anything. So if ever you're on a criminal jury and you find yourself mentally saying, well, I wonder why the defense didn't bring this, or I wondered why the defense didn't do that, that means you have shifted the burden, and that burden must not be shifted. That burden always stays with the state unless and until they prove their case beyond a reasonable doubt. Does everyone understand? So do I think they're going to be playing crossword puzzles and video games in here today? No, but they could, because the state has the burden. Does everyone understand? Yes. Is there anyone who doesn't understand that concept or cannot follow that rule? Number 15. All right, anyone else? All right, the next thing I want to talk to you about is the phases of a trial. I'm sorry, not the phases of the trial. I want to talk to you about burden of proof. I keep telling you all that the burden of proof is proof beyond a reasonable doubt. When I was in law school, you had to know the definition of that term forwards and backwards. And if you did not know it, your professor will let you know. How can you not know this? You want to practice criminal law. I knew it forwards and backwards. I knew where to put the comma. I knew where to put the exclamation point. I knew where to pause for dramatic effect. My first jury trial, I used that. After my first jury trial, guess what happens? There is no longer a definition for proof beyond a reasonable doubt. So neither the state nor the defense can give you a definition of proof beyond a reasonable doubt because it does not exist, the definition for proof beyond a reasonable doubt. Does everyone understand? So when I was a defense attorney, when I was a prosecutor, the best way I would try to explain that would by telling people what it is not. So the historic courthouse next door that has the green rooftop, they try civil cases over there. When you go to municipal court, those are a form of civil cases. The burden of proof over there is preponderance of the evidence, more likely than not. If you're ever on a criminal jury and you find yourself deliberating and saying, well, I think this happened more likely than not, you know that you are not at the burden of proof beyond a reasonable doubt. because proof beyond a reasonable doubt is higher than preponderance of the evidence. So it's higher than more likely than not something happened. Does everyone understand? The other burden of proof in the historic courthouse is what's called clear and convincing evidence. And that's the burden that is used to terminate people's parental rights, to say, you're a danger to this child. We're no longer going to allow you to legally be a parent to this child. That's another burden. That's the highest burden they have on the civil side. But guess what? The burden on the criminal side is even higher than that. So proof beyond a reasonable doubt is the highest burden that we have. Does everyone understand? Now, there are two phases to a criminal trial. The first phase, people always think it's the innocence phase. I'm finding someone innocent, but that's not legally how it is. The first phase of any criminal trial is whether somebody is guilty, not whether they're innocent or not innocent. So first phase, did the state prove their case or did they not prove their case? If in phase one, you find someone not guilty, then guess what? We don't go to phase two, because phase two is the punishment trial. You can only go to phase two if you were to find someone guilty. Does everyone understand? Now, in Texas, when someone is going to trial on a criminal case, they have to make a decision or an election that if they were found guilty, who would they go to for punishment? That's the law. When someone makes an election to say who they would go to for punishment, that's not them saying they're guilty. That's just them. They have to make a decision before trial starts. Who would they go to for punishment if they were found guilty? Does everyone understand? In this case, Mr. Dixon has stated that if he were to be found guilty, he would go to the jury for punishment. Is there anyone who's going to hold it against Mr. Dixon for choosing an election of punishment if he were found guilty? All right. So I'm going to talk to you about ranges of punishment. This is a murder case. The range of punishment is a long range. Range of punishment is anywhere from 5 years to 99 years or life in prison. Does everyone understand? And there's also a fine range up to $10,000. So if you think about it, in Texas, all of the offenses that exist, there are always these wide ranges. So when you think about a murder case, that means that if you were to find somebody guilty of murder, you could send them to 5, 6, 7, 8, 9, 10, all the way up to 99 years or life. So there's a wide range. And both parties are going to want to know whether or not you can consider the entire range of punishment. And that's consider, not give it. So when I say consider the full range of punishment, that means that internally you recognize the range of punishment for murder in Texas is 5 to 99 years or life. And then because you don't know anything about this case, right? And I've already told you both sides will only be able to talk to you in hypotheticals. When I ask people if they can consider the full range of punishment, they're always like, well, I really want to know more about it. So the way we handle that is we give you hypotheticals. For example, 5 years. That's the lowest end that you can give somebody for murder. And sometimes people will do a knee-jerk reaction and say, well, I will never give somebody 5 years. But when you think about scenarios, for example, this is the one they would always give us in law school. Husband and wife, childhood sweethearts, been married forever, just celebrated their 50-year anniversary. They go to the doctor. The doctor tells the wife and the husband he has terminal illness. He's not going to survive. They go to another doctor. The doctor says, terminal illness, he's not going to survive. It's going to be very painful. He's going to get to the point where he can't breathe. He can't move around on his own. He's going to be a vegetable. He's just going to be laying in bed. There's nothing that he can do. Does everybody have the hypothetical? And as they go back home with this information, the husband tells the wife, look, I don't want to be like that. I don't want to be a burden to you. When it gets to that point, I'm going to let you know. Just give me some pills, put them in my water, and just end it all. Help me end it all. Does everybody understand that hypothetical?
Yes.
So he gets to the point, nurses and doctors come over. and they say, yeah, this is it. We're going to have to put him on oxygen. We're going to have to intubate. We're going to have to do this. And the husband looks at the wife, barely writes down and said, remember our agreement. And so nurses, everybody leaves. She takes the pills, gives them to them. That's a murder, right? Because we don't have assisted suicide in Texas. So that may be an instance where it's murder. You say it's murder, but maybe in that instance, you would only give somebody 5 years. Does everybody understand?
Yes.
Now, then you may have the other person on the other end. Let's talk about the lifer 99. Somebody who kicked the dog in school. All the teachers like this child is going to be a troublemaker. And they constantly are picking up offenses, right? And everybody says, this person doesn't follow the rules. They're horrible. They just committed a robbery, 10 years ago. They just did this 10 years ago. And you have Mother Teresa or somebody who's walking across the street. She just came back from feeding the homeless. She has her bag. She's walking the street and somebody comes up to her, grabs her purse, pushes her down and shoots her maybe. That may be a case where you're like, yeah, that person deserves life if they're found guilty. So does everybody see the full range of punishment?
Yes.
All right. So is there anyone here who cannot consider the full range of punishment if you were to find someone guilty of murder?